Hello and welcome to this episode of the DigiPod. My name is Faria Aziz. Today I'm joined by Zishan Hashmi, who is a Lahore-based lawyer. Today we're discussing a Lahore High Court judgment which holds that OTT platforms cannot be regulated under the Motion Pictures Ordinance. Zishan, you were appointed as an amicus in this case. And before we get to your brief and what you presented to court, could you give the audience a little overview about what this petition was about and what is it that they essentially wanted with respect to OTT regulation?
When I was appointed amicus in this case by the court said something very interesting. The first thing, I appear in court and the judge says that Zishan, ye case jalebi ki tarah seedhi hai. Because the case was quite convoluted. The petitioners were companies that own movie theaters. And they were basically aggrieved of the fact that they're not allowed to screen Indian films. And so their point was that if we can't screen Indian films and we're losing out on all this market, then how come you can turn on your smart TV right now and you can watch Indian films on Netflix or Amazon Prime, and the top 10 sort of content available on Netflix or Amazon Prime at any given time in Pakistan is Indian content. And so their argument was that if we are censored by the censor boards, then the censor boards should also censor Netflix and Amazon Prime. And they were aware that the censor boards cannot censor Netflix and Amazon Prime to the extent that they can censor movie theaters. They can't block specific content. So then their argument was that, look, if you cannot block specific content, if you cannot block Indian content, then the PTA should block these platforms altogether in Pakistan.
So there were submissions, obviously, as respondents, PEMRA, PTA, provincial government, and also the federation all made their submissions, and they took a particular point of view with respect to the applicability of this law and also in terms of import regulations. Could you also speak a little bit more about what positions they took in court for this case?
The main respondent in this that was relevant was really PTA. So PTA said that, look, we do have the authority to block online content, but it's practically not possible because PTA said that technically they, under the PICA, which is the Prevention of Electronic Crimes Act, they do have the power to overall block Netflix or Amazon Prime, but they don't have the power to block specific content, not as a matter of law, but as a matter of technical issues. So that was the main respondent here in that sense was PTA. PEMRA said that it does not have the authority to go into what is on OTT platforms. And in this case, they said that, look, what we can do is we can regulate what's coming on television. We can regulate what's being shown by our licensees. But because OTT platforms don't get a license from us presently, therefore we don't have power to regulate them. And so then they also said that the petition is not maintainable. And the federal and provincial governments also mostly ran along the same lines.
And in your Marcus review, because there's been, it appears from the judgment, there has been a lot of conversation on definitions, right? And cinematography or no, sorry, that was separate. Well, so again, film and your amicus brief also relies on certain terminologies that were discussed and how OTT is distinct as a medium also, and the way that content is served to users. Could you also discuss a little bit about what distinction was drawn for the court between the traditional cinema, theater, or even broadcast content with respect to PEMRA and how this is different?
Yes, my submission basically was that if you read the Motion Pictures Ordinance, which is the law that creates the censor boards, so if you read that and you read the laws that precede the Motion Pictures Ordinance, they all apply to exhibition of a film by means of a cinematograph. Now, cinematograph is something that, again, you've had difficulty saying. I also had to keep on saying it in order to rehearse while preparing for my arguments in court. It's a very antiquated term. It's anachronistic, actually, at this point. It doesn't really make any sense in the kind of lingo that we have in the 21st century. So my point was, look, if we're using this old language, then how can this old language be taken to apply to stuff that we could not even fathom existing even in 1999, let alone 1979. So the way that, I mean, I just we look at how Netflix has evolved. When Netflix started, even they didn't know they'd be doing this because Netflix started back in the 90s as a service to deliver DVDs. When DVDs started to be a thing in the 90s, Netflix starts as a medium to deliver DVDs. And so when Netflix starts as a medium to deliver DVDs, even they don't know that they're going to be doing OTT platform streaming that they'll be the preeminent provider of that. So even Netflix didn't know that that was going to happen, let alone the drafters of the Motion Pictures Ordinance. So then my point was that look, when a statute is drafted, it's drafted to meet the needs of its time, and then it's very easy to amend a statute to meet the needs of a new time. This statute has never been amended, and so if we look at the meaning of exhibition of a film by means of cinematograph, that applies to movie theaters, or at best, it could apply to VCRs, maybe because VCRs existed back in 1979, 1980. It couldn't apply to any technology which existed, which came into being after that, which was invented after that. So, that was the point I made. And so there's a very famous quotation of the US Supreme Court, Justice Benjamin Cardozo, where he says that statutes are meant to meet the fugitive exigencies of the hour. Amendment is easy, and so you can amend the statute to meet any new exigency. So that was I relied on that, and I also there's a very interesting judgment of the British House of Lords. It's a judgment from 1988 where the House of Lords said that their Cinematograph Act, which was from the 50s, could not be taken to apply to even video game arcades. So if it couldn't be taken to apply to video game arcades, which was something which is an old thing, something we've got from the 70s and the 80s, how can we start applying this to a completely different technology, a completely different way of seeing content? So that was basically what my submission was, and the court pretty much agreed with it. They cited both these sort of precedents, and they ruled accordingly.
Yeah, cinematograph is definitely a mouthful because cinematography is still something that colloquially we say, but I mean,
Yes.
this is not a word that we
Yes.
use
That
typically.
nobody, that anyone uses.
Nobody uses
Yes.
it. There's also discussion with respect to, and in the judgment itself, of what legislative intent was, or how the court is constrained not to apply or read in these definitions or apply them to OTT. Also, because they had a very distinct, as you also mentioned, a purpose, a meaning. And none of the, after the 18th, so there was discussion also of the 18th Amendment and how this was devolved to the provinces with respect to the censor board. And none of the regulation, even though OTT had emerged in some form or the other, it did not make it into the acts as well. So, can you speak also about what distinction the court or what the court was actually looking at with respect to not legislating?
Right. So the court basically was saying that after 1979, 1980, the Motion Pictures Ordinance was never amended. And then when you have the 18th Amendment come in 2010, 2011, then you have different censor boards being made in every province. And so none of the provinces even amended their legislations to bring OTT platforms or anything other than movie theaters basically into the fold of the motion pictures ordinance. There was some case law that perhaps VCRs could come into it, but nothing more than that. So that is basically what the court was saying. And further, the court then basically said that, look, if you are aggrieved of the import of film being regulated by the import policy order as well, then that also is something that isn't happening here because there's no import of film. We don't have film over here. What you're referring to as film is a fundamentally different thing than what we're seeing on Netflix. It's not film in that sense. It's a film being a physical thing doesn't exist in the case of OTT platforms. And I had even submitted that, look, even if you say that the film that is being used by movie theaters is now digital. It might be digital, but they're still on some kind of a physical media. OTT platforms are entirely different and require an entirely different kind of legislative framework. And look, the other countries have done that. Now, India has passed a regulatory framework for that as well. And so, if we were to do it, then we need to do something like that. We cannot come to a court and expect them to do it.
So, of course, there's been a lot of conversation about whether OTT can or how it should be regulated. Similar with digital platforms, and this is an ongoing debate in Pakistan, and you see that in the PTA submission as well, where it's essentially PICA or the rules under it, the social media rules, and still it's just either you block the entire service because you can't do it to pieces of content. And what the judgment also seems to reflect is that it would be virtually impossible to pre-screen or pre-censor all the content that is available, and it's also delivered to the user. Your submission also cites the FCC example, which is a regulator in the US, but it seems that the approach has been to stay clear of OTT regulation per se. Could you also speak a little bit about what you cited with respect to the FCC?
Yes, so the FCC, the American approach generally, I mean, so accepting what's currently happening in America, generally American jurisprudence or American law gives a very wide ambit to freedom of expression. The FCC kind of follows that, and so when the FCC has been looking into whether they how they should regulate OTT platforms, they basically said, look, I mean, it's not practical and it's not something which is which sort of works with respect to the way that the FCC works for them to start regulating OTT platforms, and they have recommended, in fact, that the U.S. Congress should not bring OTT platforms under FCC's mandate. So even in the US, where the F the FCC has in the past, in the 90s, they sort of took a stronger stance at regulating the kind of language that was used on cable television. Even if they've pulled back from that as well. And so they said, look, there's no point. They said it's futile and unnecessary to regulate, to get the law to change to regulate OTT platforms. So again, I mean, even if the law were to change to get them to do it, the point is the law would need to change. So in Pakistan as well, that's what Justice Kamran Sheikh held in his judgment as well. That look, if even if you do want to do this, then you have to drastically change the law, and so you can't just get up and start regulating this without the parliament getting involved.
Now, obviously, with respect to law, we see that changes do often happen if there's we've seen how PICA was amended, or also the social media rules have been applied, but there's also a tech aspect to it, right? Whether it can be applied or not. There's not a lot of discussion in the judgment. So there's one aspect of the technical capacity or what you can really implement, even if you lay down something in law. The other thing that seemed apparent in the judgment is also to try and extend the Article 19 exceptions to content on OTT, and the futility, it's a little complicated. Could you also sort of get into that discussion on what was attempted in terms of Article 19 and 19A was cited too?
The when I part of my brief, a very small part of it, I sort of I made a submission in court that there's no point in regulating morality in this way, that it doesn't work. And so the data that I used basically was that, look, if you look at the countries where morality is regulated, violence against women is much higher as a statistic. That's just the data, that violence against women is much higher. And I feel like, look, if women are a majority of the world's population and violence against them is higher, that means that violence against most people is higher. So that's not that I feel is an objective way to measure morality, if there is any. So I was just about to say this, and I was just about to make this whole submission, and the court said, look, no, we understand this. You don't need to worry about this. So ये बात तो है that this is something that this particular bench recognizes. But I mean, if you look at Article 19, uh, there is no freedom of expression in Pakistan. Then that is the way I would read Article 19 is the way that Professor Mark Tushnet of Harvard Law School reads the First Amendment of the American Constitution, and he says that it's a non-establishment of religion clause, right, in the First Amendment. So I would say that there is a non-freedom of expression in Pakistan. So if this goes to any other bench, I mean, there could be a problem because you see, the way that Article 19 is worded is not to give freedom of expression and to create so many exceptions that there is none really. I mean, the way I view Article 19 as a non-freedom clause, not a freedom clause, and that's a bad thing. And hopefully one day it can be changed. But currently, as it stands, that's not the case. This bench understood the impracticalities of trying to apply the non-freedom of Article 19 to this issue, but we never know how another bench might see it in the future.
There's also something raised with respect to audience, and your brief also addresses this a bit, where it seems as if the petitioners also said that they're losing an audience or market because of OTT, and that distinction has also been drawn. And you discussed this also in terms of those who consume OTT content and them as cinema goers for specific types of content that's available or screened.
Yes, so again, the data wasn't available for Pakistan, but for India and for the US, the data and globally as well, the trends that I sort of looked up were that those people who view OTT content generally are the kinds of people who go to the cinema as well. So there has been a drop in cinema viewership all over the world. A lot of that had to do with the pandemic. And so post-pandemic, there's generally been a drop, but there's no correlation between OTT and a drop in cinema viewership. If anything, there was a correlation between the advent of HBO and this sort of prestige drama television with The Sopranos and The Wire and these sorts of this sort of programming, and then movies coming on to HBO as well back in the late 90s and early 2000s. So there was a correlation between that and a drop in cinema viewership, but there has been no correlation between the rise of OTT and the drop in cinema viewership. If the drop has been attributed to the pandemic, but yes, generally people who have multiple OTT subscriptions are also those who are regularly going to the cinemas.
There's also, you've referred to the AIC's submission with respect to the PEMRA consultation on OTT regulation. And we know that from time to time there have been attempts to basically make PEMRA the regulator for OTT. And that has been opposed for various reasons, some of which are evident through their statement and the discussion also. Because of the distinction of the medium, what came up during this case in terms of discussing that, and we ultimately we might have some form of regulation, but what would be reasonable or unreasonable regulation, especially keeping the distinct medium in mind?
Yes, so far the AIC has tried to sort of convince PEMRA that look, it's very difficult for you the way that you're operating and the traditional services that PEMRA regulates and the online services that come with OTT platforms. They're so different that the kinds of mechanisms for licensing and the way that you have coercive power over a cable service provider, that sort of doesn't work with OTT platforms. And so even otherwise, there is a bit of I feel at least, and so Pemra would disagree with me, I suppose, but I feel that there's a bit of a weird sort of a regulatory overlap where the Pemra rules say that the motion pictures ordinance can apply to television. And so therefore the petitioners are trying to stretch it and say that, look, if they can apply to television, um, it can apply to OTT as well. I think that provision of the PEMRA rules is incongruous with the PEMRA ordinance. And so when you have rules or secondary legislation which uh, aren't in congruity with primary legislation, then the secondary legislation is supposed to be invalid. That's something the court hasn't ruled on, but I think it will be litigated at some point. So I look, as if you ask me, I think nothing should be regulated, nothing should be banned. I think that all of this, I think PEMRA should be dissolved also. But as far as I'm concerned, I'm a very big sort of free speech, sort of free expression sort of person. मेरा तो ये ख्याल है इसमें से कुछ भी नहीं होना चाहिए. And I think that is the most reasonable sort of thing that could happen. I think anything that is happening right now with PEMRA or PTA is entirely unreasonable. So, but then that's the thing with reasonability that we try to think it's objective, but it's in fact very subjective.
Now, on that note, as we round up this conversation, again, with regulation, and it's always there's this impending doom that something will come at some point, and we've seen already that there has been regulation, and the conversation has been, and it appears in this as well, that to go down, and again, to go down the route that India has is also worrisome, because a lot of things that are happening in the regulatory space there are being criticized by local advocates. But in terms of this mindset where make everybody a licensee and regulate them through licenses, and that's traditionally been the approach, the PEMRA approach, which then they try to apply to online social media platforms through the rules, but they have yet to establish offices, and it seems that even for OTT. Now, again, if we could just sort of round off with again the distinction between the mediums, and also how licensees and what they generate and put on their channels goes through a totally different medium and a check, versus things that are either user generated or third party generated or hosting services, and how those are fundamentally different from what we know as channels, or for example.
Yeah, so the kinds of again, if you look at the PEMRA ordinance, which is made in 2002, even in 2002, we can't envisage what's happening right now. So it goes back to the same thing that if they do wish to regulate OTT platforms, they'll need to amend the ordinance, PEMRA ordinance wholesale. They can't just bring in new rules to regulate OTT platforms through PEMRA. वो एक तो वो करना पड़ेगा. अच्छा, if they do that, then I mean overall I think that's not a good thing. If anything, we should be stepping away from regulation or of free speech in any kind of way, rather than stepping more into it. But yes, so in the same way that if that I feel like cinemas should not be censored in this way, television should not be censored, OTT platforms should not be censored. The specter of censorship is going to remain if some part of it is censored. So that is the problem which will be there. If the government decides to do it through rules, I think that's something which can be fought in the courts at a sort of a better footing. But if they decide to do it through primary legislation, that's a much more difficult fight to fight. Even if you have a good bench like we had in this case, there's only so much that even a good bench can do in the face of a primary legislation.
And finally, any concluding comments on your side with respect to, there's this judgment, hopefully it'll hold, but we don't know, perhaps the petitioners will feel aggrieved by it enough, and it lands somewhere else. But this is one judgment, and also, I mean, like you said, primary legislation, the way that it gets changed and amended these days, you also don't know what. But are there any examples that you feel from other global jurisdictions, India and the US aside, where you think that those are still better to look at? Where, of course, there's about child safety, or there are other things, concerns, but there are reasonable ways to do that rather than censor or basically police adults what they consume privately, and especially because that distinction between public exhibition was also drawn in this case, where this is a very different medium. People don't consume content unless they go to it, and only what they opt for, and it's being consumed privately, and that does matter.
Yes, so I mean, yeah, one of the arguments that the submissions that I made was that when you go to the cinema, that is a public act in itself, and so that again is a different matter as to what the state deems should be publicly exhibited. Again, that's again I think not something that the state really should step into anyway. If we want to look into child safety, then there are many other mechanisms that can be brought into place as to if we should have a rating system. Now we don't have a rating system. Rather than sort of regulating things by placing blanket bans, we should have a rating system that if you're not this old, then you can't view this kind of content, or such kinds of content can only be played in, let's say, such kinds of cinemas. And these are so many things that can be done in that respect. And there are sort of, when you open Netflix or any of these sort of platforms, then there's a kids option as well. And so regulation, as Justice Kamran Sheikh notes in the judgment as well, that regulation, a lot of it is in this sphere is self-regulation. That look, if you don't want your kids to watch something, you put on a child lock or or you only give them access to the kids version of it. And so there's so many ways to regulate this outside of the purview of the state. As far as look, I mean, even the Constitution can be amended very quickly, in a matter of a few hours. But it's really a matter of the political will involved. And so when the political will comes in to amend the primary legislation for this, then that's a day that we'll have to sort of all be wary for. It seems like it might not be here right now. The petitioners might file an appeal. I don't know. Let's see if that happens. I don't know if I could be involved in that as an amicus, but I just hope that this judgment holds because this is a salubrious development for our law.
Zishan, thank you for joining us on the DigiPod. This is all that we have on DawnNews English today.